Okay, for purposes of the record, we are here on hearing, I guess this is cause number C-223-529-C in the interest of SCT. And we have had some preliminary conversations about what we are hearing today, but we are, what has been set definitely is a motion to quash the testimony of Judge Thorne in a motion for new trial. And there has been some discussion as to whether other motions to quash have been set and whether the motion for new trial has been set today. I was appointed to this case yesterday, and I am not prepared to entertain the motion for new trial today without having some background in this case. So the only thing that I was prepared to hear today was the motion to quash the subpoena for Judge Thorne in the motion for new trial. And that's what we are going to hear today. So for purposes of the record, we might say who is here. We have Mr. Roebuck. You are representing Judge Thorne.
That's correct, Your Honor.
And we have Mr. Taylor, who is present, and I believe you're representing yourself, correct?
Yes, ma'am. Yes, ma'am. I'm pro se.
Okay. So these are there are other people here, but their issues are not being entertained today. So they can stay or go or whatever. I'll probably stay because we're going to decide what we're going to do next after we hear this motion to quash. So Mr. Roebuck, your argument is under Rule 605 of the Texas Rules of Evidence, a judge in a case is, by rule, is not a competent witness in the case.
That's correct, Your Honor.
Okay. And you also, I believe, have said by extension, he is not competent to testify about what occurred in the case.
Correct.
And that the record will speak for what happened in the case.
That's correct, Your Honor.
In terms of the facts.
Yes.
Okay. And now we're going to hear from Mr. Taylor, his response.
Yes, ma'am. Under to Mr. Roebuck's argument under Rule 605, the presiding judge may not testify as a witness at the trial. This is not the trial. This is a motion for new trial. So this is not in the same trial that the sitting judge is sitting. Also, Judge Thorne is retired. He is no longer a part of this unless he is assigned. At the same point in time, he has been removed. The competency to this is the fact that underneath 601 of the Texas Rules of Evidence, it in layman's terms is a dead man's rule, right? Is that every person is competent to be a witness unless these rules provide otherwise. An insane person or person lacking sufficient intellect. Unless the judge wants to claim either one of those, which if that's the case, then it's going to be huge to think that he could have been sitting through the entire trial at that portion of it. I would say that Judge Thorne absolutely should and be testifying into this. And one of the statements I would make to that is the judge must be called as a witness, as this has gone beyond the bounds of his judicial duties. He has not followed the oath of which he is supposed to protect the Constitution, one. The second one is the family code, which he is supposed to upheld. And this is now moved to a criminal actions. These things need to be investigated, and Judge Thorne should have to testify to what has actually occurred in his courtroom at this time. Case law states.
Let me just interject here. We are the only thing I will be hearing in that regard is a motion for new trial and whether or not a motion for new trial should occur. And
Yes, ma'am.
I'm gonna, we're not doing any criminal investigations or anything of that nature. So I'm just, whether there is basis for a new trial.
Yes, ma'am. And I'm just giving you the reasons why I believe that Judge Thorne should absolutely have to be a fact witness in this case to what's happened.
Well, I'm only interested in the motion for new trial. That's
And
all
that-
I'm interested
Yes,
in.
yes, ma'am. And that's what I'm bringing my argument towards, is that under Texas rules of 601, he's competent. He has sufficient evidence. And under Texas rule 605, this is not the trial at which that we would have been called.
Yeah, but it's about the trial. And it's about what occurred in the trial.
Yes, ma'am. And I guess post trial actions would be exactly a part of that, either pre or post trial, not during the trial. So my argument is the rule is very clear on the fact that I can't call him during that August 22nd through 26th timeframe of the jury trial as a witness, but this is not during that time frame. The rules in my mind is very clear as to he can be a witness, a competent witness in this new trial that you will be hearing.
Okay, so Mr. Robach, he's saying that rule only applies to the trial, not to what happened at the trial in the motion for new trial.
Yes, ma'am. I hear what he's saying.
And what do you say to that?
I say he's wrong.
And why?
I think it's all part of the same proceeding, Your Honor. And in fact, it's how can I put this? He's asking that a trial judge be compelled to testify in a new trial
In a
about,
motion for new trial.
yeah, in a motion for new trial in matters that went on during the trial of the case.
Right.
I think it's all the same thing.
Well, it's certainly very, very irregular. And I'll tell you, it on the face of it, it sounds like that's not allowed. However, I'm going to do some research and
Judge, may I also may I also put one thing into input for this under case law ex parte Bruce 112, the Southwestern 3rd District 365.
I'm sorry. What? Wait. You're way too fast. What?
I apologize. I'm sorry. I get to reading. Ex parte Bruce 112 of the Southwest 3rd District in the Texas Appeals Court of Fort Worth in 2003. Ex parte Bruce supports the proposition that a judge can testify at proceedings after the trial. In this case, a judge was allowed to testify at post-trial proceedings to determine whether or not the presiding judge was allowed to testify when a different judge rules over post-trial proceedings. And this is ex parte Bruce. These
Okay.
are post-trial proceedings. And I would just put that on the record for you, is that
Okay.
it happened under his watch in his court during the trial against the orders and things that he put into place.
Okay. Have you have filed a motion for new trial?
I did. I'm the one who filed it. Yes, ma'am.
And when did you file? It?
Within the 30 days allotment, December
I mean,
20th.
it's on file now. Okay. I am going to have to read that before I can make a ruling in this case.
Yes, ma'am. And I've also filed an amended so that you get the adequate documents that you're supposed to have. I know Ms. Kaufman and Mr. Peterson have filed a response, and I have filed an amended to that.
Okay.
And
Well,
they have been served, e-filed. The whole process has been done. It should be with the district clerk.
Okay. Well, what I am going to do is I am going to get the motion for new trial. I am going to read that. I am then going to rule on the motions to quash based on the motion for new trial because I don't know what they're being asked to testify about. until I see that. And then we will set the motion for new trial after I've had a chance to do that.
Judge, may I only ask, I did put it in part of my motion for if we're going to continue this, is that there is a day allotment, right? At 105 days, it becomes a procedural issue with appeals and things of the nature as far as a new trial goes.
If we overruled by operation of law.
Judge,
Yes.
may I be heard on that point?
Sure, you bet.
Thank you. This case has already been overruled by operation of law. The motion for new trial was overruled on February 4th. And I can give you the dates for your consideration if that would help.
It would.
The final order was signed on November 21st of 2022.
So November 21st of 2022. Okay.
Yeah. Yes, the motion for new trial was timely filed on December 20th of 2022.
Okay.
The rule of Texas Rule of Civil Procedure 329B, subsection C, says that a motion for new trial is overruled by operation of law based on the date the court signs the judgment.
And it was signed on November 21st.
Yes, plus 75 days.
Okay.
So if you do the math, there were 9 days remaining in November after the judgment was signed, 31 days in December, 31 days in January, 4 days in February equals 75 days. So all of these motions to quash, the motion for new trial, any attempt to raise any objection to the judgment aside from an appeal has been overruled by operation of law. And by the way, Mr. Taylor has an attorney who has filed a notice of appeal. So I think after you consider basically what he's trying to do is retry the case, I think, in lieu of an appeal. But be that as it may, he's filed his notice and that's what needs to happen. We need to get on with the appeal. But before the court spends a lot of time thinking about this, it's pretty clear on the math, it's been overruled. And as Judge Thorne was pointing out in his comments, we tried to set this hearing earlier. In fact, we tried twice. And Mr. Taylor is the one who insisted on moving the date back. So being mindful that he's a pro se plaintiff, Judge, we tried twice to have this hearing before.
Objection, Your Honor. That's not facts.
Okay.
We have the emails that we could show for that. So I don't think
Please not interrupt the speaker. Yes.
Yes,
so
ma'am.
Judge, I don't think you have any discretion here based on the rules that it's already been overruled.
Okay. And tell me your name again. I'm all confused about who's who.
I can only imagine with all these people. I'm Sonia Kaufman, and
Sonia Kaufman. Okay.
and Tom Peterson and I represent the mother.
Okay.
And
Okay.
during the trial, Mr. Taylor was represented by an attorney.
Okay.
He has since fired that attorney since the order was signed.
Okay. All right.
He does have an attorney for the appeal.
Okay. So,
May I respond?
just a minute. Let me decide who's going to talk next.
Yes,
So,
ma'am.
Ms. Kaufman, you were saying that it is obvious that the last day for the motion for new trial to be heard before it is overturned by operation of law was today?
It was February 4th.
February 4th. Okay.
If you count the days, yes.
Okay. Okay. And I don't know, what is today? Today is February 7th. Okay. All right. So now, Mr. Taylor, what is your response? Ms. Kaufman says the law is clear. The motion for new trial has been denied by operation of law. So this is all moot, and your only recourse at this point is your appeal.
Thank you, Judge. I would argue the fact that the original January 30th date was moved on the request of opposing counsel. And then the dates were because opposing counsel was going to be out of town for reasons. We could not have that put into a specific week because of that. And then we did not move it forward because of that. The other side of that is that the objection to Judge Thorne having any action inside of here under Government Code 74 was still being heard by the administrative judge for a ruling, which he obviously made a ruling and you've been appointed to this. But the court still has 30 days of plenary power after the motion of new trial is overruled by operation of law. So the court still can hear the motion of new trial. You still have 30 days of that plenary power after this. If this would have been able to be heard prior or a date to that, we would have done that. Judge Thorne, under the government code, I had an objection. I raised the objection. So to have Judge Thorne rule on any of that supersedes the fact of the operation of law. But a court always has 30 days of plenary power after the final order. I understand the argument based off that, but you still have the power of that 30 days to still make the ruling of the motion of new trial to be heard. And it was time, as Ms. Kaufman stated, it was timely filed. The very first time that it was supposed to be heard was January 30th, and opposing counsel stated that they could not hear it on that date. And since that time, the date has been constantly moved out because of that, along with administrative ruling on Government Code 74 for his removal from this case, that which now you are just stepping into with all of us here today. So you still have the 30-day plenary power to do that under Rule 329B, paragraph D. You still have that.
Okay, Ms. Kaufman, what is your response to that?
Well, Judge, the law is clear. It's been overruled. So if it's overruled, how many times do you get to come back and file it again? The rules say you get to file one motion for a new trial. And the other problem he has with the motion is it was not verified. So under the rules, he cannot put on any evidence if he files an unverified motion for a new trial. And all of these subsequent amendments are after the 30-day period in which a motion for new trial must be filed. And I can give you the rule site if you would like on that, but the courts is not able to even consider anything he said in any of these amended motions after that 30-day deadline. And that is under Texas Rule of Civil Procedure 329B point C, subpart C. It says that any amended motion may be filed without leave of court before any other motion is overruled and must be filed within 30 days after the judgment is signed. So under that rule, the last day that he could have filed any amendments to have been within 30 days of the judgment would have been on December 21st. So as recently as yesterday, he's filing additional motions, trying to file affidavits, do these things. The court cannot consider any of that. I can give you a Texas Supreme Court side if that would help, but an amended motion filed after 30 days from judgment may not be considered by the court by rule. And also, for example, of one case, in Ray Brookshire Grocery, 250 Southwest 3rd, 66, Texas Supreme Court, 2008. So it's pretty clear on the law that the motion was defective, that it was overruled as a matter of law, and that any attempts to amend that are not permissible. So again, we need to move on with his appeal if that's what he intends to do. That's his only remedy at this point.
Okay, Mr. Roebuck, do you have anything to add to this?
I think Ms. Kaufman is exactly right, Your Honor. I mean, the law is clear. The 75-day deadline is failing to get a hearing on that motion for new trial vitiates the court's plenary power. period.
Well, what is it? What is the 30-day? What do you have 30 days of plenary power to do? What do you have to do? What can you do?
Well, you gotta file a motion for new trial. Within
But I
30
mean,
days.
what do you have 30, it says the judge has 30 days of plenary power. What does that mean?
To sign any orders or judgments, anything that needs to happen, we need the court to sign an order stating that it's been overruled as a matter of law. So even though the 75 days has expired, the court has the authority to do that. And if necessary, the court has the authority to quash these subpoenas, but I believe they become moot because they pertain to the motion for new trial.
Okay, well, I think the only thing left for me to do is become an expert on motions for new trial, which that will be my job today. And I'll just a minute. And I will, what my plan is, I will then file a written ruling on this motion for new trial status and what we need to do about these motions to quash. Now, Mr. Taylor, tell me what I think you have some response.
Yes, ma'am. With plenary power of the court, you still have the power to grant a motion of new trial. Even if it's been overruled by operation of law, the motion of new trial does not need to be amended in order for the court to grant a previously overruled motion of new trial. No, nothing in this has been ordered that this motion of new trial is not going to be heard. Obviously, you're here today. At the end of the thing, you can do anything as long as the court has plenary power, which you have, Judge. You have.
Where do you get that information?
It's in the 329B section, Texas Rules Civil Procedures. A motion for new trial shall it be filed prior to or within the 30 days of the judgment, other than an order complied with signed. So whether it's been.
I got all that. I want. What does plenary power mean?
Plenary power to you have the authority to grant a new trial or to vacate, modify, correct, or reform the judgment within 30 days after the judgment is signed. You have that order. You have that power.
Okay.
And it was
And
timely.
you're reading that where?
Texas Rules of Civil Procedure.
Okay, that's what I'll look at. Okay, well, what I'm going to do is will make a ruling today on whether the motion for new trial has been by operation of law has been denied, and if not, then I will rule on the quashing the subpoenas for participants in the trial to testify about occurrences in the trial. So that will be my job today. I will then file it with the court, and we'll see what happens next. Anything further, Mr. Taylor?
I would only state, Judge, that none of this was argued beyond the February 4th. I understand it's February 7th, but none of this was put into play until today. For them to have any type of affirmative defense to that would be prejudicial to where we're going in this trial and my opportunity and a right to a new motion of new trial.
Okay.
Based off what you have in front of you.
Right. And Mr. Bobuck, anything further you?
No, ma'am.
Okay. And Ms. Kaufman?
Well, Judge, as we pointed out, the motion itself is defective. It's not verified. So there are all kinds of other issues we can raise if in fact there's a hearing on the motion for new trial, but that of course is not necessary.
Okay, well, I shall try to become an expert on motion for new trials by the end of the day. So, and I will file something with the court. So I thank you very much, and I will be in touch with the court.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, Judge.
All right.